Hello everybody and welcome to History Bite number 102, dated November 3rd, 2020. I'm Walter, your mobile historian and blue-collar scholar. This History Bite is entitled The United States Courts of Appeals. The U.S. Courts of Appeals are the intermediate appellate courts of the U.S. federal judiciary. In that latter, they sit immediately above the U.S. district courts and immediately below the Supreme Court of the United States. The U.S. Courts of Appeals are essentially the successor courts to the U.S. Circuit Courts, which existed from 1789 to 1911. Okay, when circuit riding was abolished once and for all for U.S. Supreme Court justices in 1911, okay, these courts became fully independent judicial bodies, staffed exclusively by their own judges. No more Supreme Court justices sitting along with them, okay? From 1911 to 1948, they continued, however, to be named circuit courts. In 1948, Congress renamed all of these judicial bodies to the U.S. Courts of Appeals. The U.S. Courts of Appeals, like the district courts, are not created by the Constitution itself. Only the Supreme Court is. The U.S. District Courts and the U.S. Courts of Appeals, instead, were created by the Congress under its power in Article 3, Section 1 of the Constitution to create tribunals inferior to the U.S. Supreme Court. All right? The U.S. District Courts and the U.S. Circuit Courts, okay, were created in the same Judiciary Act of 1789, the same act that brought the Supreme Court itself into full existence. All right? The district courts remain to this very day, and the U.S. Courts of Appeals, like I said, are the successor courts to those original U.S. Circuit Courts, which existed for much of the nation's early history. All right? So with that in mind, okay, the U.S. Courts of Appeals, unlike the district courts, and also unlike the U.S. Supreme Court in certain circumstances, the U.S. Courts of Appeals exercise only appellate jurisdiction, which means that the U.S. Courts of Appeals only hear cases that have been heard in another judicial body first, okay? You do not originate a case at the U.S. Court of Appeals, all right? That would have to be done at a court with original jurisdiction, such as one of the U.S. district courts, okay? The U.S. Courts of Appeals only hear cases that have been heard and decided by another judicial body or administrative agency beforehand, all right? That said, okay, the U.S. Courts of Appeals primarily hear cases on appeal from the U.S. district courts, from administrative agencies and other lower federal courts as required by the Congress. There are 13 U.S. Courts of Appeals. 11 of them cover specific groups of U.S. states, numbered 1 through 11, okay? The 12th, the U.S. Court of Appeals for the District of Columbia, covers exclusively the District of Columbia. The 13th, the U.S. Court of Appeals for the Federal Circuit, is a very limited jurisdiction court of appeals that may only hear by law certain types of specialized cases, all right? Even though that court has national jurisdiction, the type of cases that it can hear are very limited. If you want further info on that, look up the U.S. Court of Appeals for the Federal Circuit. It is also the newest. It was created in 1982, okay? So going back to the first 11, okay, the United States itself is divided into 11 circuits covering all the U.S. states, okay? And these circuits, of course, range very greatly in size and population, okay? In my own home state of Maryland, we are covered by the 4th Circuit. The 4th Circuit Court of Appeals encompasses the states of Maryland, Virginia, West Virginia, North and South Carolina, okay? The 4th Circuit Court of Appeals has 15 judges, okay, just to provide you with an example. The smallest circuit is the 1st Circuit, which covers most of New England. It is staffed by only 6 judges, okay? And the largest circuit is the 9th Circuit, all right, which is staffed with 29 judges. And by far, the Ninth Circuit and its decisions affect the most Americans, as there are 61 million inhabitants within the territory of the Ninth Circuit, and that is roughly 20% of the American population. Okay, so that's a lot of people that are covered by the Ninth Circuit's decisions. Okay, just to give you some perspective on the sizes of some of the circuits. All right, you know, like I say, each of these circuits 1 through 11 covers a specific group of U.S. states. All right, and the states within those circuits are bound by the decisions of the Court of Appeals within that circuit. All right, now to the judges and procedures. All judges of the U.S. Courts of Appeals are Article 3 federal judges that have to be appointed by the President of the United States and confirmed by the U.S. Senate before assuming their office. Once confirmed by the U.S. Senate, they go on to serve for life until they retire, resign, pass away, are impeached and removed from office, or could possibly be elevated higher to the United States Supreme Court. All right. There are 179 authorized judgeships for the U.S. Courts of Appeals, though some of those may be vacant or pending at the present time, and each of them earn approximately $223,700 per year as their annual salary. All right. So with respect to procedure in the U.S. Courts of Appeals, as I mentioned to you earlier, these courts exercise only appellate jurisdiction, okay? No trials are held here, no introduction of evidence, no juries, no any of that, okay? These courts hear only, okay, appeals from lower courts and administrative bodies, okay, regarding errors in the law, okay, as well as possible errors in legal procedure. All right. They review the record from the trial court as well as hear oral arguments from the attorneys with respect to the mentioned potential legal errors in the law and legal procedures as well. All right. Most, if not all, appeals filed with the U.S. Courts of Appeals contain a lengthy amount of documentation supporting the cause in the appeal, known as briefs. Okay, sometimes briefs can run maybe about a dozen or 2 pages into sometimes hundreds of pages of supporting documentation. All right, and all right, the judges read these briefs. Okay. And when the case is argued at the U.S. Courts of Appeals, all right, the lawyers explain in thorough detail with the limited amount of time that they're given to argue before the judges exactly what went wrong in the lower court, where the lower court went wrong in interpreting the law, what type of procedural issues did not get followed right here. Okay, these are the things they argue. Okay, the reason that you're here in the first place. Why are you here? Who, what, when, here? Who, what, when, where, how, and why. Okay. Once a case is submitted to the U.S. Court of Appeals, all right, they make their decision accordingly. All right. And once they make their decision, in all likelihood, it will be final. All right. The U.S. Court of Appeals, all right, although it sits below the U.S. Supreme Court, tends to be the dead end for probably 95% or more of most federal litigation, as the U.S. Supreme Court typically only accepts about 2% of the 8,000 cases that get appealed to it annually. Most federal litigation will be final and conclusive in a U.S. Court of Appeals. It, in all likelihood, will not go any farther. All right. It will not see the light of day. All right. At the U.S. Supreme Court. Once it gets to the U.S. Supreme Court, all right, by a miracle, it may get accepted. But unless that case presents some sort of very significant constitutional question, it is not likely that it will be. All right. So some other particulars. All right. The U.S. Courts of Appeals judges typically sit in 3-judge panels. All right. So 3 of them, regardless of the amount of judges in the circuit itself, will sit to hear a case. All right. In rare instances, one of the attorneys may request what's known as an unbonk hearing, in which, in theory, all the judges of the circuit will sit and hear the case. Given how large some of the circuits are, such as the 9th, which has 29 judges, that's just simply not feasible, and only about 10 to 12 of them will sit to hear the case. But for the rest, okay, an unbonk hearing, and theoretically including all the judges, may also not include literally each and every one of them, but a substantial or close to a majority of them may sit, all right? But the whole purpose of an unbonk hearing in general is to have a full court hear the case, okay? So, U.S. Courts of Appeals, like I said, essentially are the last hope for most federal litigation, all right? These courts are very powerful, very, very influential, and their decisions affect millions and millions of people, okay? As they typically will be final, okay? Appeals to the U.S. Supreme Court from them are granted very few and far in between. These cases set precedents that have to be followed, okay? These courts' decisions set binding precedents that have to be followed by lower federal courts in their circuit, all right? And those decisions are binding until they are either reversed by the U.S. Supreme Court, possibly reversed by a U.S. constitutional amendment, or they could be reversed by the court itself, okay? In many circumstances, the courts of appeals, all right, will be in conflict with one another over a particular legal issue, okay? They don't have to listen to one another, and that creates what's known as a circuit split, okay? The 4th Circuit, where I'm in, might say this, the 9th Circuit out on the West Coast might say that, and the 1st Circuit up in New England might say something totally different than the 4th or the 9th, and so you get that circuit split, all right? So, in that case, the Supreme Court will in all likelihood have to take the case to resolve the split in the circuits, all right? So, in conclusion, in sum, the U.S. Courts of Appeals, like I said, being that their decision typically is final with most federal litigation and hearing it from the district courts and making their determination from district courts and other lower federal courts, their decision will be final because most cases appealed from them will not be accepted by the U.S. Supreme Court. And until those decisions are overturned, they are in effect binding upon the federal courts in that circuit, okay? And may well be binding upon the state courts as well, depending on the circumstance involved. If it presents a conflict between federal and state law in some circumstances, all right? So the state courts would be bound as well, all right? So those are the U.S. Courts of Appeals, all right? Arguably, in some circumstances, more influential than the U.S. Supreme Court on certain matters. After all right, certain Court of Appeals decisions remain standing and are never disturbed, all right? Like that one I told you about, the Third Amendment. So it all depends. But for all intents and purposes, these courts, in most circumstances, are final and conclusive over the states within their circuit. And last but not least, for the record, 4th Circuit Court of Appeals, which covers my state of Maryland, is headquartered in Richmond, Virginia. So I thank you very much for listening to this History Bite. If you have any questions, controversies, please leave them down below, and I'll be happy to answer them. If you have not subscribed to my page, I would be most honored if you did so. Thanks again for listening. Take care, stay safe out there, and I'll talk to you at the next one. Peace.